Thank you. So this morning, like the chairman tried to encourage us about the importance of the governance practitioner as against the in-house company secretary. We'll be looking at the company's regulations 2020, the implication and application to corporate governance. Corporate governance professionals. Please, can you go to the next screen? So I saw this on a friend's status and I found it hilarious. I found it very relevant to what's happening with us right now as it concerns the CAC's new regulation, the upgraded portal, and CAC's encouraging everybody to be able to assess and file returns without the assistance of an agent, a lawyer, or a corporate governance practitioner. And then you see people are taking advantage of this. They go to the website, they want to incorporate companies without the assistance of a professional. And they end up calling you, asking you to guide them through every step of the incorporation process. So to me, I understand that so many people are worried that, oh, CAC is allowing people to do what we should be doing. This might reduce our portfolio, this might reduce our client base, it might affect our business. But to me, I see a lot of opportunities in it. If you've gone through the new CAC forms, you'll see that they are quite cumbersome, they are technical, and it requires a lot of patience for you to be able to complete them correctly. Before it was even easier completing these forms, but now it's more technical. It requires more knowledge, more technicality for you to be able to complete these forms. And I see it as an opportunity for us to be able to get in more people, to be able to get in more clients and more business. Having said that, there are also a lot of opportunities in the regulations itself and in the newcomer for practitioners. There's opportunity for insolvency practice. There's opportunity thanks to the Nigeria Code of Corporate Governance. There's opportunity for professionals to engage in board evaluation, opportunities for professionals to engage in corporate governance audits, draft policies, help companies to implement them. There's so many opportunities for us in this season, but we need to identify those opportunities. We need to grab those opportunities and take advantage of them. So when I see people worried that, oh, this new CAC portal, this new CAC regulation is going to take us out of business, I wonder why they're worried. Because instead of it taking you out of business, I see it as giving you more businesses to do. I see it as helping you to add value or create value for your clients and make them stand out as good corporate citizens. So the objective of my presentation today is to ensure that the companies we provide services to are compliant corporate citizens, that they are always in good standing at the Corporate Affairs Commission with up-to-date public records at all times. Please, can you go to the next slide? The mode this presentation is going to take is going to be interactive, like the president said. It's not a lecture, it's an interactive session. So please, let's ask questions as we go along. If you need any question, just drop it in the chat box. I'll respond to it as we go along. Mr. Ketefe, the presentation is not okay. Thank you. It's coming on. The next slide, please. The next one, please. We've talked about our objective, and then our focus today is going to be on reporting mechanism and navigating the Corporate Affairs Commission requirement. We are especially going to focus on reporting obligations and filings at the Corporate Affairs Commission. A corporate governance practitioner performs two major functions. The first one is the pure secretarial function, such as administrative duties, such as regulatory filings, organizing meetings, and keeping corporate registers and records as required under the various laws and regulations. That's the pure secretarial function. And then we have the more prestigious in quotes, corporate governance functions, which seems to be trending now, somehow at the detriment of our pure secretarial function. At times you see practitioners complete forms and you wonder that, oh, how could they have made this mistake? I remember the form CAC2, the return of allotment form, CAC2 form, as it used to be a major challenge for practitioners to complete due to lack of training and relegation of our corporate pure secretarial duties to the corporate governance functions. Both are very, very important, because if your company or the company you service is not in good standing, then it will cost them a lot of money. From experience, there are companies that I know that have lost major contracts just because their annual returns were not up to date. Just because they didn't complete their return of allotment form as them was correctly. And due to that, they lost major contracts, they lost major opportunities. So in looking at the company's regulation 2021, we are going to focus on what is new in terms of filings. We'll look at what has changed from how it used to be in terms of statutory returns, forms, and our filing obligations. And then we'll discuss some tidbits. Next slide, please. So in doing that, we're going to be talking about the Companies Regulation 2012 first. For the first time in the history of the Corporate Affairs Commission, it introduced the Companies Regulation 2012 to meet the expectations of its customers by standardizing its processes and procedures in line with the best practice. Before the Companies Regulation 2012, you will file a return at the CAC. Let's say, for example, notice of appointment of a director, for example, or of a company secretary, or change of even registered address, notice of change of registered address from CAC3 as it used to be. And then an officer, a verification officer, will query it. You will resolve the query, submit that same form after resolving the query to the CAC, and another query will be issued, totally different from that first one. So there was no standard. A verification officer will request for certain documents. You will provide those documents. Another verification officer will request for other documents. So the Companies Regulation 2012 was introduced to totally reduce standardize the CAC's processes and procedures, codify some established practices and convention not properly addressed in the Companies and Allied Matters Act 2004. The company regulations, our policy 2012, also detailed the requirements for pre-incorporation and post-incorporation processes. It redesigned the registration forms to elicit more information to meet the know your customer principles, it reviews statutory forms and fees payable for various transactions. The CRS 2012 also made provision for electronic filing of documents, standardization of memorandum and articles of association, provision of comprehensive requirements for use of the words group and holding, as well as other restricted words. The CR 2012 made provision for the submission of recognized form of identification by the subscribers and directors of companies, as well as incorporated trustees. So the Companies Regulation 2021 was issued pursuant to the powers conferred on the CAC by Section 8(1)D, Section 8 subsection 1D of the Companies and Allied Matters Act 2020. It was issued to replace the Companies Regulation 2012, and in addition to all those things that the Company Regulation 2012 addressed, it includes provisions aimed at optimizing the upgraded CAC website and registration portal, as well as the newly automated post-incorporation portal. The CR 2021 encourages the use of technology for efficient service delivery and, like its predecessor, to align with global best practices and improve the ease of doing business in Nigeria. As we all know, from 31st March 2020, the CAC discontinued the manner pre-incorporation and post-incorporation procedures and fully switched to the automated process, except for the following processes that are still allowed to be submitted manually: alteration of memorandum and articles of association, submission or filing of Schedule 14, that's the form of statement filed by banks, insurance companies, and deposit finance institutions. You can still file amendments of constitution for incorporated trustees manually. The new biannual statements required of incorporated trustees can also be filed annually. And then all post-incorporation applications that were queried and for which payments have been made on or before 31st March 2020 can also be filed manually, provided that they are accompanied with evidence of payment and the query worksheets, and they are forwarded to the Commission not later than 30th April 2021. So if you have any pending application with the CAC for which you already made payment before 31st March, if you have documents that have been queried, the CAC will still accept the physical documents to be submitted to read by 30th April. And if all things go as expected, then by 30th April, we'll move to the end-to-end, full end-to-end electronic system. So it is therefore imperative for every corporate governance practitioner to understand the new filing requirements and how to navigate the new CAC's portal. So we'll be discussing what is new. Generally, what is new with the regulation? How does it affect the portal? How does it affect us as practitioners as well? So generally, the CAC has developed an end-to-end electronic registration solution. This means that you don't need to print anything out. You don't need to send any physical document to the CAC. You don't need to send any physical document to your client. You start the process of registration online. You complete it online. You get a soft copy of your certificate, your memas, and what used to be Form 1.1 which CAC now calls a status report on the company online. This can be downloaded from the CAC portal. So this has totally eradicated, or the aim is to totally eradicate the use of paper submission, or the use of physical submission of documents to the CAC. Another new thing is entity electronic accounts. That's something else that the Regulation 2021 had introduced, the entity electronic account. What's this account? The entity electronic account was created to enhance the integrity of post-incorporation and registration documents submitted on the company registration portal. This account is created by entities, companies, incorporated trustees, LP. And once you have this account created, you have an authorized representative that goes there from time to time to update information about the company. For example, let's say we just changed our directors. Instead of going through the process of filing the new form, waiting for a verification officer to verify it, waiting for them to send in their queries, if any, and so on, you go to the company's electronic account and then just update the information. This is in line with what's going on globally and even in Nigeria as it is for people that have public listed entities. You know, on the NSE portal, if you have any information, you just upload it you upload it online, and in real time, everybody sees it. You don't have to wait for anybody to verify. You don't have to wait for anybody to query. You just, once you have these accounts created for your company, then you update as necessary. So the accounts allows registered entities to submit documents and statutory returns on the company's registration portal. It allows any information or documents submitted through the electronic account to be deemed authenticated and therefore requires no signature. So I don't need to start sending my form around the world for directors to sign. Once I upload on the portal, then it's real. It comes up immediately. It reduces the timeline for transaction as it enables an online real-time it's enabled online real-time changes to documents already submitted to the CAC. In addition to the completion of the registration documents online, electronic signatures are now acceptable. This has been proven, the electronic signature base has been proven to be a challenge because, you know, most clients are not very comfortable releasing their signatures to the CAC, so to say. So when you ask clients, for example, when you are completing your incorporation documents and you ask your client to send you their electronic signature, most clients are reluctant and oh, I'm sorry, I can't release my signature. So there are ways around this. Some ways we have found and have been working for us is to send physical forms to the client. Ask them to sign. Most people are comfortable signing forms. Once they sign and you get the form returned to you, you can crop out the signature and then you upload it. Another thing that has worked out for us is watermarking those signatures. So you put a watermark that indicates that this is submitted mainly for the CAC, for registration purpose as CAC. And if anybody copies that watermark, it's safe. The good thing is CAC asks all these things to be in JPEG, in picture form. So once the signature is copied and used for any other purpose, then anybody that is tech savvy will see that no, this is not the this is not an electronic signature, it was copied. Another thing introduced by the Regulation 2021 is Authentication of Documents. That's Regulation 3. Documents submitted through the ECC, like I earlier mentioned, the electronic accounts are deemed duly authenticated. Also, documents submitted through an agent's account on the portal are deemed duly authenticated. It's imperative, it's important as a governance practitioner, for you to have an account with the CAC, you must be accredited with the CAC, because if you are not, then you won't be able to take advantage of all those things. And once you are able to file any document on behalf of your client through your account, then it is deemed to be duly authenticated. And if you notice, most of the forms, there is no column or provision for signatures anymore, just have authenticated by. Alternative contact address, this is a new provision also, and that's regulation 5.2 of the company's regulation. It provides that where an address is not easily traceable, then the entity is required to provide an alternate address or alternative contact address. Same-day post-incorporation and registration service, regulation 7. So the CAC used to have same-day incorporation service before, but now they have same-day post-incorporation and registration service. I've taken advantage of this so many times, and honestly, it works. If you submit your document and you submit your receipt before 1 p.m., if you don't get your application out that day, you will get it the next day. It works. I know people have been complaining that, oh, they submitted and maybe they waited for a week, 2 weeks. In fact, I've heard someone say waited for 3 weeks to get his documents out, the CTC of his document. So we need to, I'm not advocating for the CAC, right? But I do understand that the CAC is working at below capacity. I think they're working at 20% capacity right now due to the COVID-19 restrictions. And I'm also aware, like we all should be, that if you deploy a new technology, you'll definitely have some teething problems. So they are still having these teething problems. But majorly, the same day post-incorporation service works perfectly well. Application for accreditation of agents and professional. There are two types of accreditation, as an individual or as a firm. So you can get accredited as an individual, like I said, or you get accredited or you get your firm accredited. So one thing I noticed is once you're accredited and you log on to your portal, every single incorporation you've ever done in the past will automatically come up. You can view them and you can check their certificates, you can check the status of the company online. But it's important to know that the CAC has the right to withdraw the accreditation of a member where it appears that the holder of the accreditation is no longer a fit and proper person to act as an agent or professional. Membership of a professional body and payment of current year practicing fee are the two most important requirements for registration as an agent. So please, if you are yet to pay your exam practicing fee, go and pay so that you easily get accredited by the CAC. Another thing that is new in this regulation is the application for accreditation of insolvency practitioners. So there was this wrong notion that is only members of the BRIPAN that can act as insolvency practitioners. CAC had clarified this by saying that chartered secretaries can also register as insolvency practitioners. You just have to show evidence that you've actually been practicing or you've undertaken some insolvency services in the past, and then you can easily get registered on the payment of a one-off fee of 50,000 naira. Do we have any question at this point? Okay, so.
Please, Ma, the questions will be taken at the end of the third speaker, so you can go ahead.
Okay, thank you. So what other provisions are new for companies? Notice of financial year end or changes therein. The practice used to be that the company, the board of directors, immediately after incorporation, within 6 months maximum, holds their first board meeting, determine the financial year of the company, amongst other things. And then the practitioner sends a resolution or a notice to the CAC saying that, oh, okay, so this is our financial year. But the new practice now, what the regulation has done is that it's created a form, a standard form for notifying the CAC of the notice of financial year end or changes therein. And this is the form CAC2. That's the new name of the form CAC2, for you to file the notice of dissemination of the financial year end. Please note that this must be filed within 14 days of the determination, or if there's a change to the year end of the company, you need to file within 14 days. Notice of change of name of a company. Before, this used to be by way of resolution as well, but the CAC has designed a form for it, and the form is now Form CAC3. Where the CAC also directs a company to change its name because it was registered under a name identical or nearly resembling the name of an existing company, or whereby a special resolution and with the approval of the commission, the company changes its name, then the CAC, you file with the Form CAC3, and then at the end of every year, the CAC will publish the list of companies that have changed their names in one national newspaper and on its website. I've had questions from practitioners as well, mostly from in-house company secretaries. And the question is, oh, so if we change our name, what happens to existing contracts? What happens to the forms we've submitted before? And you find people resubmitting Form CAC7A without any changes in the board, resubmitting their Form CAC3, resubmitting all the forms just to reflect the new name of the company. Please, this is not necessary. Once the company changes its name, it affects every existing rights and obligation of the company. Application for re-registration. This is a new thing introduced again by the portal. This can be done with the Form CAC form. Director solvency statement, which is filed along with the notice of reduction of share, is a new introduction by the company's regulation. Share capital. The minimum issue share capital. This was a major thing before the ICSAN stepped in and largely resolved the issue for practitioners with the CAC. So as we know, under the new CAMA, the concept of authorized share capital has been abolished. The CAMA increased minimum issue share capital to 10,000 naira for private companies and 2 million naira for public companies. And companies have up to 30th June 2021 to comply with the minimum issue requirements using the Form CAC5. You are expected, as you are increasing your issue share capital, you are expected to allot immediately, and you'll be using the allotment, return of allotments of shares form CAC5. Companies with unissued shares are also required to issue all shares before 30th June 2021 or apply to the CAC for an extension of time within which to issue those shares, or take advantage of the 2 years moratorium negotiated by the ICSAN for all affected companies. Please note that penalty for non-compliance is a daily default penalty on the company and every officer of the company that fails to meet the June 2021 deadline. We've talked about allotment of shares. Like I said, it has to be done at the same time that you issue the shares. Private companies can now delegate the power. Under the regulation 2012, there was a debate as to who has the right to allot shares? Is it the board? Is it the shareholders? This has been cleared by the regulations. The regulation clearly states that private companies may delegate the power to issue and allot shares to the board, and public companies may also delegate the power for issuance and allotment of shares to the board if the articles generally or specifically authorize them to do so, or if they are given specific mandates to that effect at a general meeting of the company. So notice of consolidation, subdivision, redemption of share or reconversion of shares into stocks can now be filed by way of a designated form, and that form is Form CAC 5A. Alteration of share capital by consolidation, division, subdivision, redemption of shares or reconversion of shares is now done by the Form CAC 5A. So under the old dispensation, we had the Form CAC 2.1 for filing the notice of appointment of secretary or any changes therein. The CAC had now, most of these forms, the old form CAC 2.1, CAC 7A, CAC 3, old forms are now broken down to take care of every aspect of the changes. For example, when you're changing a company secretary, before there was just from CAC 2.1. Now there are several forms that you can use for that. So one of the new form that is introduced is specifically for the removal of secretary. And you file the notice of removal of secretary using the form CAC 8A. Notice of change in particulars of secretary is filed using the form CAC 8B. Appointment of an administrator, receiver, manager, or supervisor for company voluntary arrangement is now filed using the form CAC 11. Notice of cessation to act as a receiver, manager, administrator, or supervisor is now filed using the form CAC 12. So basically, what the CAC has done is to reduce the resolutions and things that you need to submit to them. And then they have forms that make the process and then this also helps to reduce the issues of query, because there is a particular form asking you specific questions, requesting for you to submit specific documents. So you're not just giving a generic resolution, but you follow a specific process and procedure to file this. And this, we hope, will reduce the time spent on the CAC filings. Application for striking off by a company. This is also a new provision. So hitherto, a company that was incorporated but didn't commence activities, and maybe the promoters or the shareholders, for one reason or the other, decide to wind up the company, they will have to go through the whole process of winding up. Appoint a liquidator, the liquidator goes through that long process before the company is wound up. Now it's very simple, because companies that have not commenced business and that have no undischarged obligation can apply to the CAC using the form CAC 13 for them to be struck off the register of companies. Notice of statutory declaration of solvency is now filed using the form CAC 14 as against that declaration that you have to file when you're doing the voluntary winding up, the declaration that has to be signed by a majority of the directors. Notice of resolution for winding up is also now filed using the form CAC 15. Appointment of liquidator is filed using the form CAC 16. Notice of return of final meeting is filed using the form CAC 17. Form of statement to be published by banking and insurance companies and deposit provident or benefit societies. That's the 14th schedule. Is now filed using the form CAC 18. Please note that you're required to file this Form CAC 18 before commencement of business of the affected entity, and on the first Monday in February and the first Tuesday in August of every year. Failure to do this attracts very huge penalty for the companies. Extension of time to hold annual general meeting. Instead of sending an application, a written application to the CAC seeking for an extension of time, you can easily just file a form CAC 20 to get that done. Notice of foreign, exemption of foreign company from incorporation as a separate legal entity is now done by form CAC 21. And then the following companies, you know, the CAMA says that, oh, you can't commence operations in Nigeria unless a foreign company cannot commence operations in Nigeria unless it is registered as a separate entity in Nigeria. But it's possible for some companies, for example, companies invited to Nigeria by or with the approval of the federal government for the execution of a specific project. Companies are in Nigeria for execution of specific loan projects on behalf of a donor international organization. Foreign government-owned entities solely engage in export promotion activities. Engineering consultants and technical experts solely engage on any individual specialist projects under contract with any government or government agencies can file an exemption from incorporation using the form CAC 21. Another major thing introduced by the company's regulation is persons with significant control. Please, you are too fast. So notice of persons with significant control, that's the form CAC PSC 01. A person with significant control is a natural or juristic person holding up to 5% of the shares or interests in a company or limited liability partnership. A person holding 5% of voting rights, holding the right to directly or indirectly appoint or remove a majority of the directors or partners in an LLP, having the right to exercise or actually exercising significant influence or control over a company or limited partnership, or having the right to exercise or actually exercising significant influence or control over the activities of a trust or firm, whether or not it is a legal entity, but would itself satisfy any of the four conditions. If it were an individual, is now considered to be a person with significant control. And then you are required to file the notice of person PSCs within 1 month of the receipt of the notice of significant control. So a PSC is expected to inform you once it hits that limit of 5%, and then you're expected to file the notification at the CAC within 1 month of the receipt of the notice, and also disclose this in the company's annual returns. Then you are also required to inscribe the PSA, person with significant control, against the name of such persons in the register of members. If you fail to do this, then you incur a daily penalty for default against the person or company and every officer of the company. Notice of change in details of shares of persons with significant control. Anytime the shares of these PSs, anytime there is a change in the shares of these PSs, you are also required to inform the CAC immediately using the CAC PSC 02. So that's it as far as companies are concerned. Then we're moving on to limited liability partnership and limited partnerships. These are two new entities introduced by the CAMA 2020. Before the CAMA 2020, LLPs and LPs were only recognized in Lagos State. So features of LLPs include corporate personality, limited liability, perpetual succession. There must be at least 2 designated partners who must be individuals. Where all the LLPs are corporate entities, they need to nominate individuals to act as designated partners. LLPs are required to keep proper books of accounts for each year, and contributions of partners can be in cash or other forms of contributions like real property or services. The rights and interests of a partner in an LLP is transferable, and consequently, a change in the partnership will not affect the existence, rights, or liabilities of the LLP. That's one major thing, new concept introduced into the CAMA introduced by the CAMA 2020. The LPs are similar to LFPs, and the major differences are that LPs are limited to a maximum number of 20. The LP must have at least 1 general partner and 1 limited partner. The general partner is liable for all the debts and obligations of the partnership. The liability of the limited partner is restricted to the capital contributed or agreed to be contributed to the partnership. And the limited partner does not have the power to bind the firm or participate in management of the firm. Otherwise, he will be liable for all debts and obligations the firm incurred during the time he acted as a general partner. So those are the major differences between the LPs and LLPs. So what are the forms for filing the returns for LPs and LLPs? Like you can imagine, because they are new concepts, there are new forms, a whole lot of new forms for them. Application to register the LLP is Form CAC LLP 01. Notice of change in their registered address is filed using the Form CAC LLP 02. Application for change of name is using the LLP 03. Notice of change in particulars of the partners, you file this by using the LLP 04. Then the partner must inform the partnership within 15 days of the change in any of its particulars, and then the LLP is required to file the notice with the commission within 30 days of the change. Admission of a partner of a limited liability partnership is now filed using the Form CAC LLP 05. You are also expected to file the notice of admission of a new partner within 30 days of the change. Notice of cessation of partner of a limited liability partnership is used using the Form CAC 06. Annual return of limited liability partnership is filed using the Form CAC LLP 07. It's important to know that when you default in filing within the required time, then there is a daily default penalty for each partner for every day that the default continues. LPs also have their form for reporting, just like the LLPs, and we've listed them out. Application to register the LP, LP01, there's LP02 for notice of change in principal place of business or branch address, LP03 for notice of change of name, LP04 for filing the annual returns, and then notice of change correction in particulars of a partner is done using the LP05. The partner is to inform the partnership within 15 days, just like the LLP. And then the LP is required to file the notice with the commission within 30 days of the change. Notice of change in the objects of the LP is filed using LP06, and you are required to file the notice within 30 days of change. Notice of cessation of partner of a limited partnership is done using the LP07. You are also required to file the notice with the commission within 30 days of change. Remember, there is daily default penalty for each partner for every day that the default continues. And that's what we should try to minimize as much as possible as professionals, as corporate governance practitioners, our clients, wasting resources, scarce resources on penalty payment. So we have the responsibility to make sure, advise them tell them that as soon as any change is happening, they should let you know. As their company secretary, they should inform you. So because we are not in-house, it's a bit of a challenge getting this information if you are not close to your client. So you need to be close to your client. You need to always contact them and be in touch with them, so that when they have anything going on, or before they even do it, they get you involved, and then you are able to advise them on the steps to take. What is new for incorporated trustees? Change of name of incorporated trustees is now filed using the CAC IT2 rather than sending the resolution and all those. Section 845 introduced a new requirement for incorporated trustee to file biannual statement of affairs. Regulation 32 prescribes that the biannual statement shall be made up to the 30th of June and 31st December every year. And then you're required to file this statement not later than 15th July and 15th January of every year. The biannual statement is filed with the form CAC IT05. Notice of merger of incorporated trustees. I remember this also caused a lot of furore, where people were complaining and saying, no, you can't force us to merge. If we don't want to merge, I would say they have the power to merge us. Thank God people now understand, after a lot of engagement, that CAC will not force any two organizations to merge. So if you're filing the notice of merger of incorporated trustee, you'll file that using the form CAC IT6. Section 849 of CAMA provides that two or more associations with similar aims and objects may merge under such terms and conditions as may be prescribed by the Commission. Regulation 35 enumerates the conditions to include similar aims and objectives. Resolution passed by 75% of members of each of the association. So where a majority, 75%, super majority of the association is not agreeing to the merger, then it can't be done. Then you are required to publish this in 2 newspapers and then display the notice in a conspicuous place at the headquarters and branches of each of the association for at least 38 days. And then you need a scheme of measures sanctioned by the Federal High Court before you are able to file the CAC IT6 at the CAC. This of alteration of constitution of incorporated trustees, as mentioned earlier, this can still be done manually, and it's not one of those processes that the CAC has fully automated. So what has changed? What has changed? The application to register a company, the form CAC 1.1, has substantially changed. Like I mentioned earlier, is an end-to-end process, electronic process. You complete the forms online, you get assigned online, you file online, and then the CAC issues the certificate of incorporation, a soft copy. You don't have to go to any courier company to get your certificate, because a soft copy is issued online. And it includes so many new things. A few of those things is director service address, different from the director's residential address. Prescribed particulars of rights attached to shares. Concept of class of members where applicable. Subscribers may elect to have their information kept on the public register. So it's possible for subscribers to say, okay, so after filing, what comes out is the status report that you get will not show the names of the subscribers, but the subscriber can elect to have their information kept on the public record and register. This will be displayed. And then a major issue is still the PSC, people with significant control. Return of allotments of shares. This was formerly the Form CAC 2A, but it's now Form CAC 5. Please note that this form cannot be used for transfer of shares. Hitherto, when you have transfer of shares, what most practitioners used to do is, aside filing the instruments of transfer, share transfer, they'll complete the Form CAC 2A. They'll leave the first section blank, section A blank, section B blank, and just complete section C to reflect the new shareholders of the company. This is no longer acceptable. In fact, the CAC has stopped accepting instruments of transfer or registration of transfer from 31st March 2021. So what you can now do where you have transfer is to reflect the changes in the shareholders while filing your annual returns. We've talked about allotment of shares, that it must be done at the same time the shares are issued. We've talked about private companies delegating and public companies being able to delegate the power to allot shares to their board. Notice of register address or head office address. This used to be the Form CAC 3, now it's Form CAC 6. The form now recognizes the concept of head office address. Before, it was just the registered address of the company. It's now no longer a mere notification requirement, as a change in the registered office address will not take effect until the Commission has registered the notice. Changes on the board. Formerly, you had Form CAC 7A to file any changes on the board of directors. Now, different forms are deployed to file the different moves by which the change on the board occurred. For example, appointments of directors is filed using the Form CAC 7. This also introduced the concept of service address for directors. What CAC has done now is the residential address, although you're still required to provide the residential addresses of directors, the CAC will no longer make this public. So the residential addresses of directors will no longer appear in the company's public record. It is a service address that will appear. The concept column is no longer required to be signed by the new director. Remember, we talked about the entity electronic account, where the authorized person can easily update all this on the company's electronic account. Notice of vacation of office, removal or resignation of directors, termination generally, is now filed using the Form CAC 7A. So there are different columns on this form. There is one for vacation by removal. There's another one for resignation, termination, tenure expiration, or others. Notice of change in particulars of directors is now filed using the Form CAC 7B. And like I mentioned earlier, it introduces the concept of service address. If you have a change in other details of the directors, such as their email, telephone number, nationality, correction of gender, change of country or state of residence, or change of business occupation, you file all those changes using the Form CAC 7B. Notice of appointments of company secretary. Before, it used to be the Form CAC 2.1. That's particular of person who is the company secretary of a company or any changes therein. Now, there is Form CAC 8. So for individuals, the service address, remember we talked about removal of company secretary using, you filed that using the Form CAC 8B, then you also file change the particulars of the company secretary separately. But now, if you want to file the notice of appointment, just the notice of appointment, you file that using the Form CAC 8. Particulars of charge, which was the Form CAC 8, is now Form CAC 9. Please note that the form must be delivered to the Commission with a certified copy of the instruments creating the charge for registration within 90 days from the date of creation of charge. If delivered outside the 90 days window, it will be rejected unless it's accompanied by a court order extending the time for delivery. This is why it's important as a practitioner to stay close to your client, to know exactly what they're going through or what is happening to them. Because if you have this particular charge created, then you need to file within 90 days. If not, the notice will be rejected unless you get a court order extending the time for the filing. Statement of satisfaction of all or in part of a charge, formerly CAC 9, is now CAC 10. So before, the old form did not recognize satisfaction of charges and part, but this new form does that. So we also have annual returns of companies. We are not there yet. Please, can we go back? Not business name now. We are still on companies. Annual returns of companies. So formerly, separate forms were used for filing the annual returns of companies depending on their classification. So from CSC 10 was this for filing the annual returns of small companies, CSC 10A for filing the returns of companies other than small companies, and 10B for filing returns of companies limited by guarantee. This form has been collapsed into a single form and is known as the form CAC 19. This form specifically requires the annual returns to be delivered within 14 days of the date of AGM. It introduces classification code number for the principal activity or activities or brief business of the company. The classification type could be small company, private company limited by shares other than a small company, and company limited by guarantee or public company. What is a small company? It's important that we understand the concept of a small company because of the many benefits attached to it. For practitioners, so many practitioners have been complaining that the CAC says, oh, they don't need to have a company secretary anymore. And then because of this, it will affect our business. The CAMA, then I've heard people also saying that, oh, the CAC does not have the power to fix the turnover or to fix the qualification for a small company. So just to mention that the CAMA gives the commission the discretion to fix the qualifying turnover and net assets of a small company. So there is no debate on that, on whether the CAC has a power to change, because the CAMA says the turnover of a small company should not be more than 120 million. The company regulation fixes the turnover as an amount no more than that prescribed by the Finance Act. And then the net asset value to half of that amount. The Finance Act currently fixed the turnover also a small company to 25 million. So for any company to qualify as a small company, its total turnover for the year must not be more than 25 million. And then its net asset must not be more than 12.5 million. And then we have the other qualification. None of its members is an alien, none of its members is a government corporation or agency or nominee. And for a company having share capital, the directors hold about 51% of the company. So if you ask me, I think very few companies will qualify as small companies using the 25 million turnover and net assets of 12.5 million requirements. So the annual returns also make provision for the list of past and present members. If you recall, we discussed that the CAC no longer accepts transfer instruments or transfer of shares. They no longer register it. So you are expected to list all past and present members of the company, which will reflect all transfers made from the last return. The annual returns form also made provision for details of the PSCs. The PSC seems to be a big issue with the CSC. Annual report of exempted foreign companies. That used to be from CSC 10C, now is from CSC 2022. So business names, please. So for business names, what has changed? The application to register business name, although it retains its old name, CACBN1, now is BN01, it creates a separate section for partnerships. Notice of change in principal place of business or branch address of business name, BN02, now it used to be BN4. Change of business name that was BN2 is now BN03. Change in objects that was BN3 is now BN4. Notice of change or correction in particulars of proprietors, formerly known as notice of change in registered business name proprietors, is now CAC BN5. It actually retains its old name. The old form was used for filing notification of new proprietors. The new form is for filing any change in the particulars of the proprietors, including change of email, change of telephone number, occupation signature, correction of gender, correction of date of birth, residential address, service address, as well as proprietor or partner's name. Then annual return of business name, CACBN 6. Please note that you're required to file these annual returns with the financial statements of a company, and then you're supposed to file by 30th June. Incorporated trustees.
Sorry, Madam Speaker, you have about 5 minutes to round up.
So, yes, I'm
and 5 minutes actually way beyond your speaking limits.
Oh, okay. So the IT application to register the IT is now 01. I've listed out all those. It's important to know that the regulation has now classified ITs into religious, educational, literary, scientific, social, developmental, cultural, sporting, charitable, and others. So you don't need to you can't just file without indicating where the IT, the section or classification that the IT falls into. The annual returns of the IT form now includes registered office address and service addresses for the trustees. Please note that the annual returns for ITs must be filed between 30th June and 31st December for the preceding financial year. So we are done with the boring stuff and we're rounding up. Tidbits. Like I said at the beginning of this presentation, please, if you are not registered as an accredited agent, it is important for you to be registered. Because without being registered as an accredited agent, you can't even use the services, make use of all these new services, or even the portal. You can't even access the portal. So you need to get accredited. You need to get accredited and get registered as an agent. If you are previously registered as an agent, then you need to revalidate your account by 10th June 2021. I know this is causing a lot of issues with practitioners and lawyers, saying that, oh, the CAC has no rights. I know the MBA has stepped into this, has no right to ask agents to revalidate their account. Yes, MBA has stepped into this, and then pending when a resolution will be found to this issue, the position right now is that you need to revalidate your account latest by 10th June 2021. If not, you'll not be able to access the CAC services. Please endeavor to create entity electronic accounts for every company, business name, and incorporated trustee that you service. It just makes life easier for everyone. Like I said, you can update online real time. CAC is currently working at 20% capacity, coupled with all the teething problems of the new portal. Clients are frustrated, practitioners are frustrated, tensions are high. Please manage your clients' expectations to reduce the frustration. How I do this is that I promise long and I deliver short. For example, if I'm doing a same day post incorporation filing, I'll tell you that yes, it's same day, but I don't expect to get results until after 3 or 4 days. So by the time I'm delivering results that same day, you see me as a superstar. Because instead of 4 days, I'm cutting the days short by 3. So learn to promise long and deliver short. That way you'll be able to manage your clients' expectations and then reduce frustration. Familiarize yourself with the company's registration portal. Go to the CAC website, familiarize yourself with their portal. If in doubt of anything, please consult the Operation Checklist 2020. Although this was issued in July 2020 by the CAC, CAC has confirmed that its officers still use the checklist, subject to the amendments in CAMA 2020. So if you are in doubt of anything, of what you need to submit, what you need to file, the checklist is there. Please use it religiously. Then check the CAC website regularly. Follow them on social media, Twitter, Telegram, etc. There is a Telegram group for CAC dispatch documents. I don't know how effective that will be after now, since CAC is doing away with physical submission of documents or issuing physical documents anyway. Above all, always, constantly, regularly, and unfailingly update your clients on the status of the returns filed at the CAC. Don't keep quiet. Let them know the challenges you are facing. Let them know that you take them to be important and their matters are important to you. Is when clients don't really know the efforts you are putting in. That's when they get frustrated. But if, for example, now I've been incorporating a limited by guarantee since May 2020. May 2020. The certificate of incorporation is out. I just got that last month. And then when CAC issued the constitution, when they issued the memos, they issued something totally different from what I submitted to them. This is almost a year after I started the incorporation, and my client is not frustrated because I make sure that I update him every Friday. I send an update, telling him everything we did concerning that company that week. So it's very important for you to keep your clients updated on the status of the returns filed at the CAC. This will help you reduce frustration and keep your clients' loyalty. Thank you.
Thank you, Madam.
So,
is that the end of the presentation?
Sorry?
Okay, I was just telling you that the 5 minutes.
Oh, okay, I'm done, basically. Just to let you know that I reproduced the schedule of fees, new fees to the presentation, and that's what's left. So, thank you for listening.
So, sorry before Mr. Shinake, please, my apologies. Just give me a few seconds to manage the program effectively. Mrs. Bukola Norode, please use this period to attend to all the questions directed at you, so that when Mr. Shinake is also presenting or is done with his presentation, he can also address all the questions presented, so that by the time we are through with the third speaker, will only be left with maybe residue of questions, maybe 2 or 3, so that we can actually have a very nice session. I don't want us to wait until the end before we start responding to the questions. Our participants will be able to see your responses to those questions, and then we can resolve a lot of those questions, so that at the end of the third presentation, we'll be very, at least we'll be close to the expected dialogue section, whereby we can actually conclude as soon as possible. So sorry for that intervention, please.
Okay, thank you very much, Mr. President. And thank you, Iksan, for this opportunity again. Interestingly, I'm speaking from Alau's office. I'm here in Lagos on an assignment, and just yesterday I got to know that I have the privilege to attend this gathering. Bukola Uke has done so much. In fact, I wonder if anybody can give a quick overview of CAMA 2020 and the regulations 2021. This proper section is regulation, common regulations 2021. I mean, better than what she did. So it makes it should make my work easier. The truth is that I'm now confused. I don't know what to talk about and where to start from. But I'm going to start anyhow. And I expect that at the end of the session, we'll have got 1 or 2 things that will help us as governance practitioners. My understanding is that we want to know what are the implications of the regulations for corporate governance practitioners, the consequences, and what we should know. That may be superfluous, but these regulations were made pursuant to the powers of the Commission. To do that with approval of the minister. What my approach would be to go through she's done so much on the forms. So I won't talk about the forms really, except to mention 1 or 2 things. I will want to go progressively through the regulations, the core regulations, the provisions and all of that. And the ones, I will just talk about the ones that I find most critical to our operations as corporate governance practitioners. And then talk briefly on the fees, both filing and penalties, and just give general information on some things that have happened that we need to know. We have published some of them, mostly on our website, and then we have done some newspaper publications too. The first one I want to talk about is the Regulation 3, Authentication of Documents. Under this same regulation, we have come to develop what you call the entity electronic account. Now, under this regulation, what we have tried to do is to dispense with the stringent requirement of signatures, having to carry your papers to go and look for directors, or other persons that will sign every time you want to file a document. So what we have done is to say, okay, we're going to create accounts the same way you manage your online accounts. And there will be administrators for those accounts. With the accredited user, there's no problem. We have his details. Anything that is submitted using his account is deemed to be duly authorized by his client. So there will be no need for signatures, going to look for signatures before you can file this and that. So if there are issues, it also imposes a lot of responsibility on you practitioners. What that means is that you must guard your accounts very jealously. You must be sure that it's not compromised in any way. Now, when we'll come to talk about revalidation of accredited accounts, we'll talk more on this, because this is one of the major reasons why we're revalidating these accounts. The new CAMA places a lot of responsibility on managers of accounts, whether you're a public user, whether it's an electronic account for the entity, or whether it's an accredited agent's account. So we have now introduced the electronic account for entities, which is just like the public user account in the case of pre-registration of companies. Now, this electronic account for entities allow, like Uki said, is an electronic platform that allows companies to submit applications and returns to the commission electronically. When the form is online, you can go to our website, click resources, it is there. You can download it. It is a fillable PDF. So you fill it online and then you download. It is the application is manual, is offline, because we'll need the majority of the directors or the partners in a business name or the trustees in an incorporated trustees. And if it's a sole proprietorship or is one member, a single shareholder company, he has to sign. Now, the application must designate somebody to be known as the authorized officer for the purpose of administering and submitting these documents. Now, once it is created, the commission will send notification of the creation to all the directors who sign those, who sign the application, and the credentials for the account will be sent to the administrator. That's the authorized officer. Now, the authorized officer also has the privilege to create sub-administrators. But what is important is that the directors who had the powers to create this administrator also have powers to remove at any time. And they can also remove any sub-administrator created under that account. Next, I will move to, we talked about the same day post-incorporation service. Now, the requirements, that's regulation 7. It does not, it won't apply to, we don't need it for pre-registration, that's registration of entities, because the timeline for registration ordinarily was 24 hours before COVID, and we're still going back there. So if you are going to get it within 24 hours, then there's no need for introducing a same-day application, I mean, process service. So that's why we didn't bring it. Otherwise, if we had introduced it, it could have been received badly. It would have been seen as an attempt to undermine our service delivery timeline and the SLA, and to excuse inefficiency in some cases where you cannot deliver within 24 hours. Let me talk about the company limited by guarantee section, regulation 8. Like I said, I'm just selecting the regulations that I feel are more critical to us and our operations as practitioners. Now, we know that under the Act, a timeline has been provided for the Attorney General to give a feedback on any application sent to him for the registration of companies limited by guarantee. The law does not allow CAC to go ahead and register without the Attorney General approving the memorandum of association of the company. Now, the law limits 30 days for the Attorney General to send a feedback. We need to also understand this, provide the context, proper context here. What is required of the Attorney General is to respond. It's a feedback. Now, that feedback may not necessarily mean an approval. It could be that the Attorney General will need more information for him to take a decision on the application. But what is important is that there must be a feedback within 30 days of his receipt of that application through CAC. What we have done by regulation is to make it clear. If you look at the regulation 8, sub 7, it says where we do not get a feedback from the Attorney General within 30 days. Whatever feedback we get thereafter will not bind the commission, because what the law prescribes is 30 days. And if we get it within 30 days, we must be bound by it. We must act in accordance with that. But if we don't get it within 30 days, it does not in perpetuity. When we don't get it within 30 days, we'll receive it, but we'll just consider it like any other objection from the public. So it will not have a binding force on the commission, so to speak. Another thing we need to understand is that the law provides that now the commission can withdraw any certificate that is improperly, fraudulently, or otherwise procured, by means other than true and. Now, the assurance we make through the regulation is to say that these powers will not be exercised without a full inquiry made into the circumstances. The administrative proceedings committee. We'll talk about that as we go on. We must first, that committee must first make full inquiries into the matter and be satisfied that indeed these registrations were procured improperly, maybe by fraud or some other unlawful means. But there's also the assurance there that even where that happens, where we withdraw these certificates, it's always without prejudice to any agreed person. For instance, people that must have suffered some losses by reason of the incorporation of the company, or between the time that the company was registered and when this action took place. And this is understandable because in other parts of the act also, even in the case of winding up or striking off, these powers were always reserved, such that any aggrieved persons, because the truth is, by the time you are taking these decisions, whether by the court or even administratively, you may not know the extent of commitment of these entities. So the law had to step in to say, no matter whoever is involved, will take this action, but the company shall sit liable to them for whatever other remedies. In fact, in the case of it's interesting that the law will say, bring back that company, let them finish everything before you go back. So if you have a resurrecting dose, give it to the company, let it come back alive. I come and address this issue, then it can go back and die. Right. Now, there's also Regulation 12 on the power to exempt foreign companies. We need to know now that that power resides with the Minister of Industry, Trade and Investment. Before now, that power resided with the Secretary to the Federal Government, and it was administered by his office. But because of the bureaucracy, I mean, as we speak between, well, it's I think I can make that disclosure here. If you ask us today how many companies have been exempted, we can't give you a figure. We don't even know, because we had no control at all. We were not even involved in the chain at all. And severally, we've asked for information from the SGF's office. They have also come back to tell us that they don't have. So we just felt that that's not good enough. So while the act was being amended, this portion had to be amended to domicile that activity with the minister, our own supervising minister. It's easier to relate with him, and it's also an obligation on the exempted entities to let the CAC know they're exempted. The minister is also obligated to publish from time to time in the Gazette the list of exempted foreign companies. Regulation 13. This is an interesting one. We talked about minimum issued capital, share capital, and I know it's generated a lot of concerns. We even had, if you recall, there was a session on this thing. Interest of that session was whether companies were prohibited to maintain unissued share capital, shares, after 6 months from commencement of command. That is after June 30. Before I go to that, let me quickly tell you here that it's good news. The minister has approved. And I think that the idea first came when we had that session. So the minister has graciously approved, following our request to him, that the timeline for complying with Section 124, that is aligning the share capital of the company with the provisions of the section, be extended till December 31, 2022. So I know the RG did make a promise there that he will make every effort to get that done. So he wrote to the minister, and the minister has approved that. So companies don't need to apply individually. And we've had about 3 or 4 applications. Now companies don't need to apply individually anymore. It applies generally and across board. We'll make a publication in that regard. The approval just came in last week. So we'll make a publication in that regard generally, so that people are advised that they now have 2 years. That is from January 1 this year till end of next year to comply with the provisions of the section. Now, I didn't have the opportunity to talk then. I just want to seize maybe 1 minute to talk about this thing. For me, we may argue some inelegance in the drafting of the section, but if you look at it critically, you may also just say, well, there's really no inelegance. Maybe it's tasking. Yes, maybe, and maybe because of that, you can call it inelegance. Now, if you look at the definition of share capital in Section 868, it's critical to understanding the scope of Section 124. Under the 1990 Act, share capital referred to authorized share capital of a company at any time. You see the definition of authorized share capital as the share capital of a company at any time. Now the law has moved from there. The law now defines share capital as the issued share capital of a company at any given time. In other words, whatever component of your share capital that is not issued is not recognized as part of your share capital. That is what that definition says. If it's share capital, is the issued capital of a company at any given time. That means at any given time, whatever is on issue is not recognized as part of your share capital. Now, if you have a component or a part of your share capital recognized, what does that mean? It's a nullity that does not exist. You cannot do anything with it because the law doesn't recognize it. So that for me, and if you also look at the interchange, the words as used. Now, everywhere you hear minimum, everywhere you hear issued share capital, it means share capital. So if you look at section 124, everywhere you saw issued share capital, it referred to the total share capital. That is the way to interpret that section. And if you do that, you will understand that, yes, the law does not contemplate a situation where companies will exist under CAMA 2020, outside the timeline for a transition with unissued shares. Again, talking about this extension, some persons have argued that that the Commission or the Minister does not have the power to extend the timeline because the timeline is provided by the Act under Section 124. Now, the approach to it, my response to it is that CAC did not extend timeline. What CAC has done is to remit penalty. Because by the Act, the CAC can make regulations prescribing fee and penalties, Section 867. So if the CAC can say, and then go through every other, most sections that create offenses to tell you, subject to penalty, they are liable to penalties to be prescribed by regulation by the Commission. So if the Commission can prescribe penalty, then the Commission can also say, okay, in this regard, there's no penalty. So that's what the Commission has done. Because what Section 124 is doing is to say, if you don't do this before June 30, you will pay money to do it. What we're saying, okay, you don't pay money. If you don't do it, you won't pay money, so long as you do it before 31st of December. So maybe we should not look at it as extending the timeline, but remitting penalties, which is perfectly within the prerogative of the Commission. Next, let us look at the electronic meeting. The CAMA, because there's a gap. Again, a gap because a lot of people ask, is it possible? Ordinarily, it is possible. People want to know whether it's possible. And that is electronic. There's no doubt, no controversy on electronic meetings for private companies. And that public companies do not enjoy such privileges. Fine. But what about the board of directors? There's nothing that in the Act that prohibits board of directors from holding electronic meetings because Section 289, subsection 1 says they can regulate their proceedings. So if they decide to hold it by electronic means, fine. So that was what we tried to create under Regulation 16, that board of directors can hold their meetings electronically. Then Regulation 7, the next one, provides the framework for applying for restricting protected and personal information. Under the Act, for directors, and generally, even the Nigerian Data Protection Regulation, NDPR, you are not at liberty, it doesn't matter that you are a regulator, to put personal information of persons on the public record. You know, now there are concerns about security, cyber security, sanctity of information provided under confidence, and sanctity of information provided to regulators by way of compliance, particularly when the law says this information, they are available as public record. So the Act has provided that addresses, particularly residential addresses, will not be on the public record, right? And those who want it protected must apply to the Commission for that. The cost is there in the schedule of fees. I think it's 25,000 for if it's a private company, and I think 50,000 if they're for public company persons. So you can apply. It applies both to companies, business name proprietors and partners, and incorporated trustees. I won't be talking about limited partnership or limited liability partnerships because they are not currently on board. So because I have very little time, so let me just talk about companies where our practitioners are most involved, and then briefly on incorporated trustees, because it's still part of CAMA. The next thing is the qualification of small companies. Bukola did talk about it. What I want to mention here is that the threshold by regulation, because we have the powers to regulate that, is not as fixed by the Commission. It is as fixed from time to time by the Finance Act. So what that means is that the Finance Act can, from year to year, amend that provision. And the reason for that is that we don't have two regimes of definition of small companies within the same business environment. The Finance Act also defines thresholds for small companies. And so we say, okay, let us from time, let the CAMA just follow the Finance Act, since it's an annual thing. Let whatever figure the Finance Act prescribes, that is what will be the threshold for turnover and net assets for small companies. And good thing, I mean, well, even at 25 million, which it was last year and this year, we don't know what it will be next year. This is fluid. Even at 25 million, over 85% of companies will fall within that bracket. And most of them are really not active, but in case they get active. Then we talk about the accreditation of insolvency practitioners. Again, the Commission, under its powers to prescribe professional bodies, went ahead to prescribe that if you are a member of, Brightband was mentioned in the Act, but if also you are a member of ICSAN, if you are a member of ICANN, if you are a member of ANAN, if you are a member of NBA, you can practice as an insolvency practitioner. What the Act has done, where it was silent under the 1990, again, because insolvency, business rescue and insolvency mechanism wasn't really a high point under CAMA 1990. Today, you cannot be appointed a receiver or manager. You cannot be appointed a supervisor. You cannot be appointed an administrator under the company administration of companies. You cannot be appointed a liquidator unless you are an insolvency practitioner. So that now the law has made that clear. And it was because of that I now said, okay, all these other groups, professional groups that I mentioned earlier, can be accredited as insolvency practitioners. Now, for insolvency practitioners, the payment is 50,000 at registration, but there is a 2-yearly renewal requirement. Now, this was where I think the error came when there was this notice that circulated. It didn't emanate from CAC. We did publish a disclaimer to that effect, that companies should go and validate their accounts, and that if you don't validate it, it will be withdrawn or closed. And companies don't have accounts with CAC. Now we're introducing that. And there was this other fear also about the accreditation of validation, validation of accreditation, that it's a yearly thing. It's not a yearly thing. The regular accreditation is not a yearly thing, it's a one-off thing. It is the insolvency practitioners that will need to renew the accreditation every 2 years. And even that will be at no cost. So even for insolvency practitioners, it's just a one-off cost of 50,000 naira. The yearly renewal thing is just to confirm that this is the same person still practicing and that your details and particulars are still the same. Sorry. Next, we'll move to, let me talk briefly on trustees. We know that Buki did mention it, that the Act has now introduced what you call the biannual statements by incorporated trustees. This is similar to what you get with certain companies, banks, insurance houses, and some other deposit collection, provident companies. Now, with the form is there on the website. You don't need to do any other thing but populate the form with the information that is required. This is supposed to be done twice in a year, and you have a cutoff point for a cutoff date for each of those filings. The first one is June 30. That statement must be made up to June 30 of that year, and it must be filed within 15 days after June 30. That means it must be filed on or before July 15. If you file after that time, we will not refuse it, but we'll apply penalty. And it's a daily penalty. The other one, the second one, which is for the other half of the year, should be made to December 31 and should be filed not later than January 15. of the next year. Otherwise, it will also attract penalty. There's also accounting records and audit as a requirement for incorporated trustees now. Under 1990, what the law did was to say the Constitution shall provide for the audit of account, but it did not say you must give CAC a copy of that audited account. The new law requires that when you are filing the annual returns, you must accompany it with audited financial statements. You must, and then you must keep accounting records for 6 years, just like companies. You must also maintain books of accounts. You must maintain a register of your members, and you must maintain minute books. These are requirements of the regulations 33 and 34. So your clients, incorporated trustees, your incorporated trustee clients must maintain all these books and comply with all these requirements at filing of annual returns. Now, the more contentious issue of suspension of trustees, and for the academics of it, I mean, the position of the CAC is that it has not in any way derogated from the rights of persons to associate freely or assemble peacefully. If anything, it has amplified the provisions of section 44, 41, and 44 of the Constitution of the Federal Republic of Nigeria 1999 as amended. What we need to understand here is that what CAMA does is to regulate the administrative aspect, to regulate trustees, not the association. Because what the law recognizes is not the association, it's the trustees. It's trustees that are incorporated into legal personality. And by reason of that incorporation, that's a thing that is given them. The trustees now enjoy the privilege, the prerogative, the powers really to alienate, dispose with, deal in any way with the properties and assets of the association. Without that registration, the trustees don't have that power. Now that they have the power, the law has given them that power. Now, these are properties that are held in trust for the association. It is also important that the law must secure the proper administration and application of these properties and assets. That is just what the law has done. It says where there is mismanagement is defined in the regulation. Where there is misconduct is defined in the regulation. Where there is fraud is defined in the regulation. Or where it is necessary to protect the assets of the incorporated trustees, or where public interest is defined. Public interest is defined in the regulation. So these are situations that are defined. And there are checks. There are other checks. If you look at the regulations, regards to suspension, removal of trustees, appointment of interim managers. You will not suspend trustees without an inquiry by the Administrative Proceedings Committee. But before even the Administrative Proceedings Committees, you must first constitute a board of inquiry. And the board of inquiry, the requirements are clearly stated that there must be people who have experience, skills, and area of the operations of that incorporated trustee. And if it's religious or cultural based, there must be persons. If it's one person, there must be persons who are members of that religion. If it's not religious or cultural based, then there must be sectoral leaders or persons with very, very significant skill and experience in that area of operation. So you're not just going to bring a total stranger to the operations of the incorporated trustees to come and conduct an inquiry. I'm more pointed if you are appointing an interim manager, if it's only one manager you're appointing, if it's a faith-based or cultural-based association, that manager must be a member of that faith or culture. Now, when he does his own findings, the CAC cannot act without first giving every affected trustee the opportunity of response. There must be fair hearing. So you must first listen to them. And even when you listen to them, we must allow time for remediation. We must allow time for these trustees to remedy the alleged wrongdoing It is only where they fail to remedy these wrongdoings within the specified time that you can now invoke these powers. And then these powers are not even exercisable without the express approval of the minister. And before it gets to the minister, it must go through that administrative proceedings. I'll talk about that later. And the board. So there are checks. And there are certain things that the CAC cannot do. The CAC cannot set up a scheme of administration for that incorporated trustees without the sanction of the court. The CAC cannot, even the interim manager cannot touch the properties of incorporated trustees, because the law is that only a court can vest the properties of the incorporated trustees in any person, and not just any person. There's the person identified by the law under that same section. That person is the official custodian, and the official custodian is an officer of the court. So when it touches on property, it is only the court that will supervise that aspect. But the interim manager can audit you. They can ask for your papers to see how have you fed, how have you managed this property. There are allegations of abuse, there are allegations of fraud, and all that. Can look into your papers and then recommend that these persons should be suspended or removed. And the decision of the commission is subject to judicial review. You know, in other climes, particularly in UK, where we borrow this from, the powers of the Charities Commission extends to appointing and replacing trustees. We don't have that power. It's only the court that can do that. So for us, we believe that there are sufficient checks and guards in the system and in the law, particularly with the regulations that have been made pursuant to the regulations 28 to 31 to provide some comfort in these areas. The Administrative Proceedings Committee, this is a creation of this act that's come out 2020. Now, the committee has powers to adjudicate only on non-criminal disputes arising from the operations of the Act and the regulations. When criminal elements are involved in the disputes, the commission cannot sit on that. That must go to the regular courts. Now, even when you talk about the non-criminal agitations and disputes, only when they relate to names of companies, business names, limited liability partnerships, limited partnerships, incorporated trustees. When they relate to shares in private companies, and when they relate to issues around appointment, removal of directors, trustees, and partners. Those are the areas. And the proceedings, I mean, the APC has powers to regulate its own proceedings, and to that extent has made very, very surplus regulations to consider touching on timeline for filing of processes, and referral to Administrative Proceedings Committee, notice to parties, filing of briefs and exchange of pleas, extension of time, setting down for hearing, venue for sitting, and rules of evidence, which are just but they have guided by the rules of natural justice, equity, and fairness, not the rules of evidence strictly. Now, let me, I don't have a little time. Let me mention briefly some new services that the Act.
Oh, sir, you have just 3 minutes, sir.
Okay, yes. So thank you. Thank you for that. Some of the services that are new, introduced by regulation, you have due diligence, which is self-service search. Now, because we no longer allow open our files up to people, it's just to ensure the sanctity of our records. It's not really because of COVID. COVID just facilitated it. COVID made it quicker. It's been something that we have been considering for years, how we can bring search online and then reduce the incidence of opening up our files to pilferage and mutilation. So all searches now are conducted by the commission. But where it is critical, and you insist that you must see the file, there's what you call the due diligence self-service. You pay 50,000 naira, you come into the commission and come and conduct it. We give you a very conducive environment. We may not serve you tea if you want, yeah, of course, but then you have to pay for premium service. And that's actually available. That's another service that's available, the VIP lounge service, premium service. Now, and this is only available to post corporation. Now, and for applications that will not need the CAC to obtain comments from some other quarters or requiring certification. So you can come into the system. If it's just one application you want to do, file particular change of directors, you can come pay 50,000. We'll put you in the lounge, we'll give you tea and biscuits. Of course, that won't be at your prescription because we may not be able to buy all the kind of biscuits and cheese. But we'll have certain thresholds that will provide. You may even be in my office. Take sit down, relax, cross your legs. While you are waiting, we'll provide your service. It's a premium service I will give you. Right? You can bring 10 applications as long as it's upon the same company, and you pay just 100,000. If it's more than one, it's 100,000 naira. If it's one, it's 50,000 naira. Then there's also the same day service for post incorporation, which Bukola dwelt richly on, so I won't say anything on that. There's voluntary striking off. The law allows a company, provided, I mean, a small company, a company that has not has no commitments, has not started business corporation, you know, to file for striking off, remove my name from the register. I'm no longer interested, you know. And then there's restriction of special address. I said earlier. Today, we no longer give CTCs of documents because, again, these documents contain personal information. What commission issues after you file is extracts, certified extracts, which will be an updated information on the company. So you will now give certified extracts detailing every information on the company, not necessarily change of directors that you have, but every other information on the company. But you will not have signatures, you will not have pictures where there are pictures, you will not have the identification number in case of names and all of that. Now, of course, registration of insolvency practitioners. It's a new service. Notice of exemption of foreign companies. Before now, foreign companies exempted were not required to notify the CAC, and that was why it was difficult for us to even have any record of that. But now, beyond the minister publishing, the companies themselves must notify us. So that way we can now start building records on that. There's also the annual subscription for SMS alerts for officers of entities. You also know every time it occurs in your structure, there's a new filing. You can subscribe to the annual alert. It's just 5,000 naira. It's available for all of officers of the company. Electronics I talked about the premium service. And the persons with significant control, you can see that information free at no cost online. Now let me talk about the fees and penalties. What the law has done now is to take into consideration that companies and business operations and transactions come in sizes and they have peculiarities. Now, the impact of a violation and infraction, a small company may not be as far-reaching as the same violation occasioned by a public company. So the effect and the consequences on the economy. So you want to look at that, and those are the factors that have guided us in prescribing fees and penalties. So that fees are now, permit my use of the word, scaled according to sizes and types of companies. For small companies, you have 4 broad types. You have the small, you have the private other than small, you have the limited by guarantee, and you have the public companies. Now, the fees vary. The filing fee for a small company on a particular transaction varies from that to be paid by a private company other than small. And it's also different from what the limited by guarantee company will pay and the public company will pay. The same thing applies with business names and corporate trustees. Now, for fees, generally, you will find that what a small company pays will be about half or a quarter of what the public company will pay. For penalties are standardized now. All you need to know is whether these penalties are daily or they are low as one-off penalties. Now, for daily penalties, for small companies, it's 250 naira daily. For private or companies other than small, 500 naira daily. And for companies limited by guarantee, it's 500 naira daily. For public companies, 1,000 naira daily. For business names, it's 150 naira daily. And for incorporated trustees, 500 naira daily. Now, the one-off penalties for small companies, 5,000 naira. For private other than small, 10,000 naira. And for company limited by guarantee, 10,000 naira. For public companies, 25,000 naira, and for business in 5,000 naira, while for incorporated trustees, it's 10,000 naira. You need to understand, once you understand this standardization, it's easy for you to compute the penalties. Now, it is important that these penalties are stiff enough to be deterrent. You know, where the commission is not really interested in enforcing compliance. It's actually cheaper for us as a commission that operators do the needful when they should. Enforcement comes at a cost. Compliance outside time also comes at the cost to operators. So whether they file when they should file, or they come by way of penalty, extended time penalty, it will not. It's not a matter of income generation for the commission. The commission will still generate what it will generate. Imagine that all companies are filing their annual returns when they should. It will help, and it will also boost revenue. So it is cheaper for the commission and both for the operators that the system is such a system that has institutionalized what you call voluntary statutory compliance. It helps all of us. The other thing we need to know, lastly, okay, I said I was going to mention some of the notices we have sent out, and some of them have been mentioned while Bukola was talking. Revalidation of accredited agents accounts has been extended to June 10. And yes, the NBA has intervened. We have looked at it. We have even discussed it with EBs and the permanent secretary. That 10,000 naira will stay. We are still going ahead. Anybody that does not do that before June 10, the account will be suspended. So he will not be able to conduct anything for his client until it's just suspended until he does that revalidate. I said it earlier that this law places a lot of obligation on agents. We know that a lot of these accounts have been compromised. There are lawyers that we have caught severally when we have issues with applications, and they tell us they don't know about these applications. When I was in Lagos here, I had to hand 3 people over to the police. 3 people. The fact is that whether you know or you don't know, you take responsibility for these things. So it is important that we, again, satisfy ourselves that the owners and the operators of the accounts are who they say they are. We know of a chartered accountant who is dead, who has been dead for a long time. We still receive annual returns certified by him as an auditor. He's been dead more than 5-10 years ago. We still receive audited accounts certified by this same person. So you want to wonder, this certification and license that's given to auditors, do they take it to the grave? Does the dead man frank documents? So we need to know that these persons are still who they are and that the information still the same. So the 10,000 is an administrative fee. This administrative fee you paid, you were creating this account. Since 30 years of the Institution of Corporate Affairs Commission, there's not been any validation or any cost on accreditation. So that 10,000 is the advice that we all go and revalidate our accounts before June 30. Then the submission of manual applications will continue until April 30. It will continue subject to these conditions. It will continue in respect of applications that were queried before 31st of March. Because if they were queried, then we must receive responses to them and they must be concluded. It will continue in respect of applications for which payment was made before March 31st. All other applications will not be allowed manually. The only exception to applications that will continue for now, outside this one I've mentioned, there are just 4 applications because their interfaces are not ready. They are not yet online. And that is 1, alteration of memorandum of association of companies. 2, filing of Schedule 14. We are hoping that we have a commitment by the vendor that will be ready before the next due date. But we cannot wait till the next due date because these filings are done daily. They didn't file the other one before the first Monday in February, but they still file paying penalty. So that will still continue manually. The biannual statement for incorporated trustees too, the first one will be due by July 1. Just in case the interface is not ready, we will accept that manually. And the amendment of constitution, those also come manually. I think I'll stop here for now and take comments later and questions. Thank you very much.
And I'll play with you to help us manage time.
Good morning, every participant. I must welcome you all, and I want to believe we have all been enjoying ourselves in the last 2 presentations. This particular presentation is what I will call the Bible for the public practitioners, because there's no professional body anywhere in the world that does not have a code for its members. And the Governing Council of the Institute has deemed it fit to have a kind of a book, codes that codifies the code of conduct that every member of the institute is expected to comply with. So I will implore all practitioners or those that will be practitioners any moment from now to make sure you keep yourself abreast of these codes and ensure that you represent the institute very well wherever you find yourself. The Governing Council of the Institute has considered it necessary for every member holding. Mr. Kete, can you please help me project my paper on the screen? The host did not allow me to share my paper here. Hello, Mr. Ketefe. Can you please help me project this presentation on the screen? I'm not allowed to share screen here. Okay. Okay. Thank you. Can you please move the slide on? Move it up. Move it up. Like I was saying, the code is complementary to our institute charter and bylaws. We already have bylaws and we have charter, but this particular code is specially designed to guide the behavior and to regulate the attitude of professionals, practitioners, wherever they find themselves. So in this presentation, we shall first review the code of conduct for practitioners. We shall also look into the practice regulations for charter secretaries and administrators in public practice. But essentially, we are going to delve more on the code of conduct. Let me also emphasize that soft copies of the code of conduct for charter secretaries and administrators are available at the Institute Secretariat. I learned the price is 500 naira. Hard copy, I don't know how much it goes for, but I believe, I strongly advise that we should request for the soft copy of the code for everybody to keep. There are 22 issues that are dealt with in the code. The first issue is the personal conduct. A practitioner is expected to exhibit conduct that is consistent with the good reputation of the profession of the charter secretary and administrator. Charter secretaries all over the world are known to be tactful, diplomatic, resourceful, neat, and diligent. They are known to be people of impeccable honesty and integrity. So we expect all practitioners, all charter secretaries out there to exhibit this conduct wherever they find themselves. Then we are expected to comply with the
sir,
code.
You can share your screen, please.
Okay, okay. Sorry. Let me just, okay. I've just been enabled to share screen. Sorry. So while I wait for that, so you are expected, when you take on new assignments, there are standard of behavior you are expected to exhibit. You must guard against any factor that can impugn on your integrity or objectivity in relation to that assignment or appointment. Don't get a new assignment by deceit. Don't tell your client lies, and don't demarket the other professionals in the field because you want to get a new assignment. I had an experience where somebody was trying to file annual return for a newly incorporated company, the first return, and he told the client that because he has not filed within the time limit of 18 months, he has to go to court to swear affidavit. He has to get a court order to do this, and he has to pay 1.7 billion naira to do just that. Then the client got annoyed and he just contacted me that, what will it take to just file this? And I told the client, yes, you are filed out of time, but I don't think you need to pay as much as 1.750 million naira to get that. That all you need to do is just to go and get your audited account and bring it, we will help you out. So what I'm saying is that when you hear what some of our colleagues do on the field, you begin to marvel. This is not an attitude that a practitioner should be found to be exhibiting. Then we are expected to have technical and professional standards. We are holding ourselves out as somebody who is knowledgeable, somebody who is well trained, and somebody who is well versed in the profession. So you don't undertake any assignment that you don't have competence to do. And as the president said when he was doing his opening remarks, There is no harm in asking questions. We have so many practitioners on the field that you can always, request information for, ask for clarification, but don't go and do any work, any professional work out of ignorance. Don't go and make costly mistakes that will make your client to pay a penalty or that will damage the reputation either of yourself or of the client. So always make sure that you exhibit high level of technical competence in whatever assignment you find yourself to do. Then the code also talks about courtesy and consideration towards all. As charter secretary and administrators, when you go to the field, when you go to the client, you are expected to show courtesy to clients. You are expected to be considerate of the situation of the client. The client don't know, and that is why they contacted you. Don't add to their problems. Don't add to their worries. You are expected to give them objective advice on how they can get out of the problem. Don't scare life out of them. There is no problem in this world that is not surmountable. If the client has violated some regulations, or they are failed in complying with some regulatory or legal requirement, yes, and you happen to be contacted, don't scare them and don't even tell them that, look, with what you have done, I don't think you can get out of this mess. Tell them what they need to do. They have violated some laws, yes. Tell them the way out of the problem. Don't add to it. So you should be cautious as you consider of their situation. Then you are also expected to exhibit professional independence. You are expected to approach each assignment with an independent mind. Do not be biased in your in your reporting of meeting. This is very, very common, especially when there is a conflict on the board and the secretary may want to take side. It is not your business to take side. Your business is to record the proceedings of the meeting in an objective manner. Don't be seen to be taking side or to be sentimental in your minutes. You need to see some minutes. You can see clearly that, look, this secretary is trying to be on the side of somebody. If you do that, you cannot portray yourself as a real professional that you're expected to be. So do not hesitate to inform all interested parties of any potential or real conflict of interest, especially when issues have to be decided on the board. Raise alarm that, look, you may not be able to participate on this matter. You may not be able to vote on this matter because of this, and because of this. Then confidentiality. We all know that by virtue of our position as professionals, some information will come to you, confidential information, highly sensitive information. Please don't be flippant with this information. Some decisions will be taken at the board meeting, and people want to know what has been decided at the latest meeting. Don't just be so careless and so carefree to just read information because you want to call it somebody's favor. Client will oblige you with confidential information. Some privileged information will also come to you as a result of presence at meetings or certain reports presented at meetings. Sometimes when they say secretary should go out, I don't or legal or professional obligation of advertising and publicity. Fortunately for us, we are not forbidden from having a signpost at the entrance of our offices. But you can only advertise your professional service or skills in accordance with the Institute Code of Practice on Advertising. Calendars, diaries, corporate or branded materials like mugs, barrels, and t-shirts can be given to clients. But when you go and buy you go and buy a brand new car to a client, I don't know what you want that to achieve. So you can give small gifts, corporate gift to a client, but not gifts that will project you as if you are trying to call their favor, as if you are trying to cover up something. So please be moderate in the way you advertise. And when you're advertising, do not demarcate other practitioners on the field. Tell the client what you can do. Don't tell them what the other practitioners on the field cannot do. That's not your business. So we have to be very, very careful in the way we publicize ourselves as professionals and as practitioners. Then there's a code also on how we can describe our firm. You can only say charter secretaries, ABC and co-limited charter secretaries, if every director of that company
Hello, Mr. Adeoye. Okay, we apologize. It appears Mr. Adeoye's internet has frozen. I don't know, to save our time, I don't know if the head of the visitation committee is here, so that we fill in the gaps. So we fill in the gaps, please.
Yes, I'm here. Good afternoon. I think
Okay.
Ms. Adeoye is back.
Okay, ma'am. Good afternoon.
Good afternoon, ma. I think Ms. Adeoye is back. Will you please confirm that? Hello, ma.
Mr. Adeoye, are you back? I can see him on the chat. But...
Hello, can you hear me?
Okay, now we can hear you.
Okay. Sorry, we have a connection.
We together. Hello, are we together?
We can hear you very well, sir.
Okay, so I was talking on description. The code does not allow any firm or any company to just describe itself as a firm of charter secretaries and administrators, unless all the directors or all the partners therein are qualified members of the institute and they have all got their practicing license. And that is the reason why the Corporate Governance Practice Committee is advising that whoever that want to hold himself out as practitioner must get our practicing license. The chairman will also speak about it shortly. Then the non-competition code, that's number 9. You are not permitted to obtain. I hope we are together. Are we together?
Yes, sir. We can hear you.
Yeah.
Yes, so we can hear you.
You are not permitted to obtain or seek professional work for yourself or another practitioner in contravention of ICSAN code, especially some of us that work in an organization. You are supposed to be 100% committed and loyal to that organization. There's nothing like PP, private practice. So you are expected to commit to your employer. You can't be working somewhere and you're also getting PP somewhere. You are not supposed to compete with your employer or compete with the organization you work for. This is not acceptable for public practitioners. Then code number 10, obtaining professional work. This code is guiding us that when we want to get a professional work, you are not allowed to give any commission, fee, or reward whatsoever to a third party, not being either his employee or another practitioner in return for the introduction of a client. This is a very, very key code. If you want to get a job, or want to get an assignment, don't demand for 10% commission, or don't promise any of the staff of that client any commission by virtue of you getting that assignment. This is not acceptable for public practitioner. You must abstain from engaging in carrying on business of a kind which is normally carried on by a professional for on behalf of his employer, unless his employer is permitted to describe itself as a charter secretary. Sorry, we have some issues there. I hope I'm still with you. So this is also very key. Don't allow an employee of an organization. Are we together?
We can hear you.
Yes, sir, we can hear you.
Of an organization to carry out the work of his employer in partnership. Very careful about the way we see.
Mr. Odoye, we can't hear you again.
Oh, are we together now? Hello?
Now, yes.
Okay.
Now, yes, we can hear
you. The other code is regulating how changes in professional appointment is done. Whenever you are asked to leave a client, it is not a crime. It is not unusual. People go, people come. Do not, and when you are invited, when another professional is invited to that same client, the new professional is expected not to accept the new appointment without, first of all, clarifying from the previous professional what really happened. It is only in our profession that people will just gladly accept new assignments without, first of all, probing into the previous relationship between the previous professional. So when you are to accept an appointment where another practitioner was before, you must request the prospective client's permission to communicate with the previous appointee. If such permission is refused, you should decline the appointment. When the client has given permission, you must disclose all information relevant to an acceptance of the appointment. So you owe a duty to your professional colleagues on the field, because sometimes some client will owe 3, 4, 5 years fee to the past professional service provider, and they will just engage you and say, well, you can start. And you just start without finding out whether the past practitioner is being held or not. That is not attestable for public practitioner. I hope we are all going to take care of this. It doesn't happen in accountancy profession. You have to write, you have to get the permission of the client that I want to talk to the previous secretary that you had. I want to clarify with them. It is only when that one gives a written consent that the new assignment can proceed. Where a practitioner had requested for the consent to accept new assignment from another practitioner, you must obtain permission of the client to discuss the client affairs freely with the proposed appointee. If the request is not granted, you must report the fact to the proposed appointee where the written permission has been received, such shall be disclosed to the practitioner to accept the appointment. So it goes hand in hand. The new one and the old one should have a clear understanding of what is their professional requirement. I must seek for clarification before I talk to you from the client. And I must also inform the client that, yes, I want to talk to the former secretary that you had. It is only when all those permissions are received that you can proceed to the new assignment. Then, as a charter secretary and administrator, by virtue of our training, we can do so many work at the same time. We are so vast in some legal matters, administrative matters, personnel matters, and all that and all that. Before you go to carry on additional professional work, either with other practitioners or on your own, you must make sure that you notify in writing that other practitioner of the work that is proposed to be undertaken. This is not required if the client gives in writing a valid reason against it. So for instance, now they already have a
a company solicitor. And this is a work that a company solicitor should do. But you as a company secretary, they now put it to you that, can you do this thing to us? When you know that their solicitor should be able to do it. Before you carry on that assignment, first of all, seek for clearance and clarification from their solicitor before you carry it on. Otherwise, it will amount to maybe you trying to cross your bound or trying to go outside your remit. Then you can also engage in ministerial practice. If you act in association with others, not being members of the institute, either through the medium of a limited company or in partnership in the provision of the public or services, usually undertaken by a practitioner, you are deemed to accept responsibility to the institute for ensuring that in providing such services, that organization does not describe itself as a charter secretaries and administrators, but is conducted in accordance with the institute code. What this one is saying is that if, for example, you now partner with a firm of chartered accountants, and together you provide consultancy services on maybe writing feasibility report and all that, you are expected to ensure that because you are part of them, you must ensure high level of standard in whatever professional service you render to the client, because you are carrying the name of the institute to that association. So wherever you find yourself, you must distinguish yourself as a real professional. You must make sure that you perform to the standard expected of a professional. Then the other code talks about multidisciplinary practice. When you engage in providing professional services in partnership with or in conjunction with members of other professional bodies, you must avoid doing anything that may be in breach or contravention of any legal, ethical, or other requirements governing members of that other professional body. This is also very, very important. If you associate with maybe a lawyer or with accountant, and all of you are doing a professional work, make sure you don't engage in anything that will contravene the requirement of that other professional body. So that they won't say it is this charter secretary among us that is disgracing us, or that is, not behaving up to time. So you must distinguish yourself in that association and let everybody know that you are a core professional and you know what you are doing. Then if you have multiple professional qualifications, and this is very, very common among charter secretaries and administrators. Most of us are lawyers before we became a charter secretary. Most of us are chartered accountants before we became a charter secretary. Most of us are HR practitioners before we became a charter secretary. So where a practitioner is also a member of another professional body, you shall not, in providing services usually undertaken by some professional, do anything in breach of any legal, ethical, or other requirements governing members of that other professional body. So it means we are also protecting the integrity of other professional bodies whose certificate you are carrying. So because you are partly charter secretary, we are saying that you can do other professional work. Put to you the requirement that you must make sure that you give nothing less than standard. It does not matter whether what the service you are providing is secretarial service or corporate governance service or elder services. By virtue of the fact that you are also a charter secretary and administrator, we expect you to exhibit a very high level of professionalism, even though you are doing other professional work. Then, for members that want to engage in corporate practice, you may carry on as a practitioner through the medium of a limited liability company. If you so wish, you can combine with one or two members and incorporate a limited liability company. In fact, the newcomer even allows one shareholder limited liability company. If you so wish, you can incorporate a limited liability company, or you can even incorporate a business name to practice, but make sure you do everything you need to do before you just start holding yourself out as a professional, as a practitioner. A corporate practitioner must observe all the rules and standards of conduct applying to a practitioner. The CAC has just said, with effect from June now, they want to see you as accredited agent of the CAC. If you're already accredited, you must validate or revalidate your accreditation. So
It means part of the revalidation process would be to ensure that you discharge your obligation to the institute, pay all your subscription up to date, ensure that whatever requirements the institute demands of you, you meet them. If you want to also practice as an insolvency practitioner, you must make sure that you are on the good record of the institute so that you can apply to the CAC to get your accreditation as an insolvency practitioner, and they will give you the accreditation. So if you want to practice good, make sure you do everything that you need to do. Observe all the rules. CAC has our own rule. Make sure all those rules are met. And there are other standards of behavior that are expected to exhibit. Make sure all those standards are exhibited. Then every director and every registered holder and beneficial owner of shares in such a company that will incorporate, if you want to operate as a limited liability company, they must continue to be member of the institute. So if you have 2 or 3 partners in your company that are practicing as a professional chartered secretary administrators, you must make sure that every partner, every director of that company at all times regulate their membership of the institute. If any of your members has had his certificate withdrawn, that will not be too good for you. And you must make sure that all your directors are jointly and severally, and they are directly responsible to the institute for the conduct of the officers of the company, as if it were a firm in which they were the only partner. What we are saying is that if you bring people to yourself and you are practicing together as practitioners, everybody of that association must be people of impeccable character and high integrity. Then note also that you cannot describe your company as chartered secretaries and administrators unless clause 20 of our code of conduct is complied with. I told you the copies of the code is here for everybody to have. A soft copy, a copy is just a 500 naira. I will enjoin you to apply for your copy so that you can have this thing for keep at all times. It should be something like our Bible that we read every day. This is what clause 20 says. Every director and every registered holder and beneficial owner of shares in such a company shall be and continue to be a member of the institute. The directors jointly and severally are directly responsible to the institute for the conduct of the officers of the company as if it were a firm of which they were the only partner. So what they are saying is that you must make sure that every member of your practicing firm regulate their membership of the institute, and they are qualified to practice, and they are qualified to hold practicing license of the institute at all times. Then, clause 22, it says you must, as a practitioner, honor any promise or undertaking made or given in the course of your business promptly and in full. This is also very, very key. Professionals are known to be people of integrity. Don't collect money, service charge from your clients, and you now abscond. If you collect money for any document we find at CAC, and the document is queried, don't abandon that query. Don't abandon that client. You must make sure you follow it through until when everything is sorted out. That is what is expected of a professional. So don't break promise. You must honor your promise. Your word should be your bond. If you promise that a document will be ready in 1 week, Bukola just mentioned that. Don't promise your client what is not possible. Don't tell your client that I will get this document done by CAC latest tomorrow, when you are not the CAC. It is always available to have maybe a few days. Even when you know that it is possible for you to have that document in 3 days, have maybe 2 days to it, make it 5 days. If you're able to get it before 5 days, you are lucky. But don't promise what is not possible. You must be a man or woman of integrity, honor your promise, and any undertaking you take on, you must make sure you do it as expected and to the satisfaction of the client. And even when you are raising your fees, when you are charging your fees, you must be reasonable, you must be fair. Don't forget that you are not the only person in town. Whatever, and some clients, some of the Lebanese clients or these Igbo clients, they are very funny. Before they ask you to do any work for them, they have asked about 5 or 6 other people, and they be comparing fees. If the average fee that other people say is 200,000 naira, and now come and you say your own is 2.5 million naira, they may not talk, but you won't do that job. But from that day,
you will lose their confidence, and they will never trust you for anything again. So you must make sure that you honor your promise. You must make sure that you are bound by your words and you have integrity. They can cross-check anywhere. If you have to add your professional fee, let them know the actual costs. Tell them the way I charge is that I will charge for the cost of doing this assignment, and I will also charge my professional fee. Let them know your professional fee. Let them know the actual cost. That makes it clearer to them than just slam a lump sum to them that you cannot even justify. Some client will ask you to come and explain. Are we together? Hello, are we together?
Yes, sir.
Okay. Some client will ask you to come and explain how you came about the fee you are charging. Don't forget that all the fees for CAC services are on the portal. You can't tell a client that you want to find annual return for 280,000 naira. They will tell you you're a liar. You're a chronic liar. Annual return is 3,000 for business name, with penalty is 5,000 naira. Total 8,000 naira. How did you come about 280,000 naira? The day you cannot explain it clearer to them, that's the day they will now learn to run away from you. Then the code is also warning that any breach of this code may be deemed to be a matter for investigation by the disciplinary committee of the institute under section 12 of ICSAN charter. And if any member, any practitioner is found to have breached any aspect of this code, then there will be a disciplinary committee of the council that will investigate. If they confirm that that breach has actually been done, whoever member, whichever practitioner is involved can be sanctioned. In fact, it can even lead to the withdrawal of the practicing license or outright withdrawal of the certificate, because the certificate is owned by the institute. So members are enjoined to always remember the son or daughter of whom they are. We should be guided at all times by the ICSAN charter and practice code. But for the time, we will have gone into the regulations. The code also lists all the practices, all the area of practice we can go into. So, but they are not going to mention that today, but just to say that all those items that the institute has listed as the guiding principle for the members and for the practitioners, we should not shy away from them. In fact, it is advisable that every practitioner should read this code every now and then. It is something that we should be able to understand and remember every aspect of it every day, because they're supposed to be our guide. They are like 10 commandments in the Bible. If you commit them
3 minutes
to
more, sir.
if you commit those codes to heart,
just have 3 minutes, sir.
Yes, I know. You will prosper in this business. But if you don't commit those codes of conduct and practice regulations to heart, and you just feel you can just do whatever you like, yes, you can thrive for the early years of your practice, but I can assure you, you will not last. We have seen professional practicing firms that have lasted more than 10, 30, 40, 50 years. And we have seen some that started 3 years ago. After 2, 3 years, they went under. So you must make sure that the quality of the service you provide for your clients and the level of the integrity that your client can place on you will determine how long they will patronize you. So once again, I want to enjoin members to get soft copies of this code of conduct and practice regulation from the institute, which you must have. In fact, every firm must have a copy in their offices, and every practitioner should have a copy. And I want to believe that whenever people are being inducted to get their license, a code of conduct of the institute is one of the documents they must have, apart from the license, apart from the seal, and whatever they are going to give you. Thank you very much. I wish all of us all the best in our practice. God bless you.
He is, but he's muted. We'll reach out to him so that he can unmute himself.
Okay, that's fine. Thank you. Okay, the first question I think should be answered by him. It says, does the requirement to file a notice of person with significant control apply to companies already existing or just new companies? If it applies to existing companies, is there a timeline for the filing? And I would also add to this question, is there something we need to properly take into consideration concerning this issue of persons with significant control? Personally, I think issue of 5% is actually too low if you say significant control, but the regulators would advise us if there's something we need to pay attention to other than just making it as a routine filing process. If Mr. Shonaike is not here, I don't know if Mrs. Bukola can assist with responding. But I really would have preferred Mr. Shonaike to give us response to this question.
Moderator, please, whilst we are expecting Mr. Tolu to join us, maybe you can pick the questions that are relevant to Mr. Adeoye and Mrs. Agagu.
Okay, I was actually thinking if Mrs. Bukola had a response to that, she could also come in. Okay, let me go to any other one I think would suit. Because most of the questions here actually.
Sorry, I'm sorry, I was at my network.
Okay, Mrs. Bukola. Okay, that's fine. So, do I repeat the question?
Please, please, please.
Okay, a question was asked by an attendee. It says, does the requirement to file a notice of person with this significant control apply to companies already existing or just new companies? If it applies to existing companies, is there a timeline for filing? Then in addition to that question was, is there something that practitioners to take into cognizance as a matter of focus on this new issue for paying attention to persons of significant control during filing? Is it just a routine, filing or filling of information? Because when you say persons of significant control in a company where you have you could have someone with let's say 90% shares in the company or 95%, and someone with just 5% is also filed as significant control. I would have preferred or would have thought that the 95% would have been more of CS's concern. So I don't know if there's something as practitioners we need to pay attention to on this new requirement.
Okay, maybe let me address the second question first. Maybe a context to help here. These disclosures requirements for persons with significant control arose globally because of concerns for money laundering and terrorism financing and movement of illicit funds using the cover of corporate vehicles. Now, the concern becomes a concern when persons hold at least 5% of controlling rights. I like to put it like that, significant control. It does not have to be by shareholding alone. If you look at the definition of PSC, under section 6H, it sometimes may not be about shareholding. Sometimes you have people who don't have shares or who don't have 5% shareholding, but they have voting rights, maybe because of the kind of shares they're holding. And sometimes people don't even hold shares. They don't have to come to meetings. They are not recorded anywhere. They are not entitled to come and vote at your meetings. But they actually determine what happens. Those who are on record who determine come to meetings and all that cannot take decisions without recourse to them. They can influence the composition of the board directors. When I say composition, appointment or removal of majority of the board of the directors. So the trigger threshold is 5%, right? The concern is that if you hold 5%, you have enough control for the system to be interested in you, right? It's different from majority shareholding. We should get it. It's a totally different thing. So for everybody who hits that threshold, 5% and above, The law is interested in their particulars. The law is interested in their particulars. So it's not just about whether the person holds 90. Once you have people who hold 5%, all of them, you must disclose their particulars. Then the first question that addresses whether for existing companies, whether you need to disclose those particulars. Well, generally, we know that laws do not operate retrospectively. So I would expect that your filings, because if they were persons with control then, and if they are still persons with signal control, that means it should still be disclosed. If they no longer are persons with signal control, then the interest is not in them anymore. Because the registers they are supposed to keep is here forward. The ones that are supposed to keep, maintain, and keep updated, it's here forward. So for when you are filing, just file those details for the recent ones. I understand the challenge because to file now, you have to use the new form. You cannot use the old form. The old forms are not even available online anymore. Right. So, and then you have to use the new form. And the new form is asking you details of persons with significant control. The good thing is that once you are able to file one annual return, the system auto-populates for the next one. So what our advice is, just file one successfully, and then when you come back to file the other one, it auto-populates it. So you don't need to start the same information. You don't need to start editing. Just click and submit. Just change the year and submit.
Okay. Thank you so much for that explanation. I don't know if Ms. Bukola is here. There's a question for her, directed to her.
Yes, please, I'm here.
Okay, the question to you says, concerning same-day posts, incorporation or registration, could you please elaborate on the actual process? The fee payable, the process, is there a separate email address to send applications to? And if it's there, can you provide us with that address?
Yes, I already did. The email address for same-day post incorporation filing. I already posted this on the group chat. So if you could just check, the email address is samedaypost@cac.gov.ng, and then the fees payable are 30,000 naira for limited by guarantee, 20,000 naira for small companies, 30,000 naira private companies other than small companies, and 50,000 naira for public companies. These fees are payable in addition to the filing fees. And it's your normal process. Just send the email with the receipt of payment to samedaypost@cac.gov.ng before 1 p.m.
Okay, thank you. So, Ms. Ashonaike, this question goes to you. How do we as professionals...
Yes.
Okay.
Yeah, but so
how
I just
do we
wanted
as
to mention
professionals...
that. Please
so
go
I
ahead.
want to say something.
I'll take it together. Please go ahead. I'll take it one at a time.
Okay. The question is, how do we as professionals reconcile the anomaly of CAMA prescribing 120 million turnover and 60 million as net value to qualify as a small company for the year, only for the regulation made pursuant to the Act to completely ignore that provision and follow the Finance Act?
Okay, I thought, well, I believe I addressed that, and Bukola also did. If you look at Section 394, that prescribes these conditions for small companies, and those two subsections, paragraphs really, on turnover and net asset, it did include a clause which says, or such other amounts as. So what does the room to prescribe amounts, thresholds for turnovers and for turnover and net asset from time to time. So that 120 million for turnover and 60 million for net asset is not fixed, is not cast in stone, and it is within the remit of that flexibility that the commission decided, because the commission has the power to prescribe, to change that amount. It was in that instance that the commission then decided that, look, we're changing this amount. It will be 120, it will be 60 million, right? And we won't put a figure because there is yet another law that will always be updated that touches on the same subject. You cannot have two regimes on the same subject within the same business environment. If we say we fix it at maybe 50 million or 100,000, and then the Finance Act comes and says, so don't forget that most of the things that touch on FRS also touch on CAC. So if you are saying for the purpose of for FRS and taxes is 25 million, and then for the purpose of filing with CAC is 100 million, those are inconsistencies that will be tied in any system. And don't forget that we do not operate in isolation. We operate in a global economy. And by reason of that, we have subjected ourselves to so many protocols and so many international, multilateral arrangements under which you have peer review groups, you have global reforms and all of them. And they come to see as they see your system, come to test it and to validate some of your claims. How do they reconcile this thing? As far as they are concerned, the world is concerned, small company is small company. Why can't you be having two different definitions of a small company within the same space? So it was important that this thing be aligned. And that was why CAC, in its wisdom, decided that, look, don't fix an amount. Leave it to the Finance Act. Whatever amount the Finance Act fixes from year to year, let that be the amount for the purpose of determining turnover and net assets. I hope that addresses the question. I was trying to say on the earlier question about same day post incorporation, we need to also note that that application must be made online. It's not just the email. You must submit that application online. And then you now make the payment before you now send the mail, and you pay this amount outside the system and then send the mail so that we can know that you have made that application online.
Okay, thank you very much, sir. Electronic accounts. Could you please, someone asked for clarification on what it means and how does she own one, or does she need to own one in?
Okay, no, a practitioner does not need an electronic account, an entity electronic account. No, a practitioner does not need it. It is not designed for practitioners, right? And that is why it's called entity electronic account. So the individual practitioner is not an entity. It's your clients that need them, these accounts. So it's companies, business names, and corporate trustees that can apply to create an entity electronic account. As a practitioner, all you need is your accredited agent account.
Thank you so much. Well, this question is directed to you, Mr. Shonaike. Does business name now have to submit audited reports? Because we knew before now, for business names, all you need to do is pay your prescribed fees for annual returns. But it appears online. There's that column provided there for updating statement of accounts. So this question is asking, or this person is asking, if we now need to submit audited report for a business name.
No, you don't need audited report. What you need is a statement of affairs, income and expenses concerning that business. But it is not an audited account or statement. It is exempted from the requirements of audit, right? A simple statement will do. A simple financial statement will do. You don't need the requirement. It does not need to be audited or be under audit.
Okay, sir. Well, I'm trying to scan through the questions because some of them, I think they've already been answered. Some people are asking for slides. Okay, now, this question to Mrs. Bukola. A corporate director represented by a certain individual seeks to change representative since it's no longer part of the company. How does one effect that with the new system? And in response to this question, the corporate director is equally a corporate subscriber. How does one effect this also? The person is saying the application, maybe Mr. Shonaike may have to be the one to answer this. It says his application was queried as a result of name similarity. Is this new system, how does one effect the changes?
Okay, I'll allow Ms. Ola wants to go first.
Yes, so
Please.
corporate directorship is alien to our karma. There is nothing like corporate directorship. So a corporation cannot be a director. What the corporation can do is to appoint someone to represent it on the board. And it's a person's name that is reflected on the form you'll be filing as the director representing that corporate entity. So where the corporate entity now changes that person, you just file your the necessary form reflecting the new name of the director still representing that entity. So there is nothing like corporate directorship. That's the point. It's the individual that you change and you reflect the individual's name. I hope that answers the question.
I think that should answer the question. So, Mr. Shonaike, I can hear you. I think that would have answered the question. Mr. Shonaike, you can give the complimentary response to that.
The class is very, very, on point on that. There's nothing like a corporate directorship. Corporate bodies cannot sit as directors or be represented by nominees, appointed for a particular period. And
sorry, if I may also add something. Hello?
Yes. Yes, Mr. Adeoye, please.
We must at this juncture distinguish between a director and a shareholder. That a director is removed. If that a director is also a shareholder, he still remains a shareholder. The process of removing a director is different from the process of removing a shareholder. The question the man has, he said the same director is also a shareholder. He can be removed as a director, but he still remains a shareholder unless a resolution to remove him as a shareholder is also passed. So I just want to note that.
Yeah, Mr. Adeoye, you may even have to answer this question because you are a seasoned practitioner from the firm of charter secretaries. Do you require a CAC form to notify? Okay, well, I think the person is trying to ask if one can have one, or what are, if CAC has a form for acting secretary, and what is the procedure to be adopted?
That's a very interesting one. What CABA says is that a company should have a secretary, and when you have one, you notify the commission. There's no provision for acting secretary. You have a secretary. If the secretary is not available, he can nominate his assistant, his deputy, to stand in for him. But in the records of the commission, the substantive appointment is recorded there. There's no provision for acting secretary. It's just like there's no provision for assistant director or deputy director in CAC. CAC recognizes a director. A director is a director. There's no acting secretary. I hope that is clear.
That is very clear, sir.
Okay, sorry, can you refresh? There was
we'll
the
just
question
say this last question. I think we tried.
No, sorry, there was a question you asked me.
Okay, sorry.
I can't remember that question now. I only spoke, added to what...
I thought you... Okay, I thought they had been answered indirectly.
No, I can't remember.
In relation to that first question, in relation to that first question, the corporate director is equally a corporate subscriber. How does one affect?
No. There was another. There was another question. I can't remember.
Okay.
There was another question.
My application was queried. Okay, my application was queried. Yes, my application. Yes, this is the question. My application was queried as a result of name similarity in this new system. How does one affect the changes?
Okay, now this is a very critical one because it happens from time to time. Now we've, I believe we published some notices on that, on how to resolve it. Such issues cannot be resolved within the platform on the application. So what happens in such instances is that when you are required to change your name after your application has been submitted and approved for certificate generation, where you are required to do that, what you need to do is go get another name approved. Once that name is approved, while pushing back your application in response to the query, upload the notice of approval as any other document. Upload the notice of approval as any other document. And push it back. When it gets to us, we will see it. And then we will go to the back end to effect all the necessary changes to the document and generate your certificate. The same thing happens where, for instance, you are undercapitalized for the object you want to do, and for maybe the object requires 25 million and you only have shares of 5 million. And then you are queried to go and increase your capitalization to 25 million.
Okay. Thank you so much. I think we've taken a lot of questions. For those that we could not address their questions, because I noticed some of them had to do with some things you could actually raise as a complaint to the CSC platform. So maybe we should use that medium. I don't know if Mr. Shonaike wants to be magnanimous to offer, because someone asked for his contact. Someone asked for his contact. I don't know if he wants to do that, but we're not compelling him. If he's contact to contact you, because Mr. Shonaike.
Oh, I see. That's a tough one, because that's a very tough one. Look at I see Justin making face that what's tough about it. And Justin, it's a tough one. Okay, I'll give you anyway. But, I mean, it's just that I'm always I'm very busy really, and some people don't also respect this protocol of privacy. They call you in the night, and every time you receive a call, you don't know who it's called. You have to be nice, and sometimes your mood is not nice.
We understand, sir. We understand, sir. Mr. Shonaike, am I the only one that can hear him?
No, you are not. We can't hear him.
Okay. Okay, but I think it's
sometimes you're under some no, it says you just whatever your mood you must reset. Can you hear me?
Yes, we can now. We lost it for you.
Okay, so I'm going to call it, I won't type it. So if you don't get it, you don't get it. I'll call it only once. Okay, so it's 0909. 0909.
Okay.
404 0036.